action over exclusion. Bottom line, when you bid on a job and present a policy with an action over exclusion, you're essentially telling the GC and the building owner that you will leave them high and dry in the event of a problem. As such, they are less likely to transact with you. The policy you would be presenting might have sufficient liability limits, but the application of those limits will not be utilized in a way to protect your partners. If you are in a construction business, you will likely at some point bid on a job where having an action over exclusion on your policy can be a deficiency. What is the exclusion and how does it apply? While each state's laws are different, this is a general understanding of mechanics. Employees are typically precluded from suing their employers for work-related injuries. If an employee gets hurt on the job, the employer's workers' compensation policy gets triggered to cover damages to the employee. While the law restricts the employee's ability to sue their employer once a workers' comp policy is engaged, they can sue other parties who had negligence in the loss. For example, a building owner hires a contractor to do work on their premises. The contracting firm's employees falls off a ladder. The employee can access their employer's workers' comp policy to cover their medical bills. Suppose the employee feels the building owner was negligent in not letting them know the floor was unstable. They can sue the building owner separately from their employer. Now, typically, the building owner's contract with the construction firm will have wording demanding the contractor hold them harmless and indemnify them. So if you have an action over exclusion, no problem. The contractor's policy will get triggered and will defend the building owner. However, if there's an action over, you have no exclusion, you're no problem. If there is an exclusion, no coverage would be extended to the building owner, even if they have a different certificate naming them as an additional insured. In states like New York, the law puts ultimate responsibility on the GC and building owner. As such, they are very sensitive to hiring firms with this sort of exclusion. Moreover, very liberal states have personal injury attorneys advertising very heavily. Promoting personal injury lawsuits to injured employees as such is a hot topic. Even in Miami, Florida, typically more conservative than New York or California. As I drove down I-95, I noticed a tremendous amount of personal injury ads. Bottom line, when you bid on a job and present a policy with an action over exclusion, you're essentially telling the GC and building owner that you will leave them high and dry in the event of a problem. As such, they are less likely to transact with you.